Welcome to Brown & Joseph. We're happy that you stopped by to view our information. Today we're going to be talking about the impact of the pandemic on the litigation services, better defining when to sue and not sue. Before I get started, I wanted to introduce some of our team members who contributed to this information that we're reviewing here today. Tom Yotis, formerly of CNA and was past president of ICE. Ellen Reinhardt, who has many years of experience in the industry, has also joined our team in August, as well as Dave Robbins, who's been working with me closely for the last 5 years and just recently promoted to Chief Operating Officer. COVID-19 is starting to take its toll across America, and it's forcing businesses to close, leaving millions of people unemployed. COVID-19 came in February and changed the practices across the board, not only on litigation, but in billing, internal collections, external collections. There's been a lot of changes. To add to that, court systems are backlogged, and many are shutting down, and they're operating at reduced capacity. In March and April, new court cases hit an all-time high at 110% increase. The expectation is a continued increase as the stimulus packages deplete. If a second stimulus package is not approved and state mandate closures resume business, debt will continue to rise. What we see here in 2008 is the level of bankruptcies in 2008 when the financial crisis began. There was a huge increase in 2009 and even into 2010 where they were at a higher level than 2008. In 2008 to 2010, business closures exceeded bankruptcies 3-to-1. A recent article said commercial bankruptcies are now up 33% for the year. So we'll be watching that closely. At this point, we're still trying to determine what the trending is going to be here in 2020 to 21 and 22. But following previous trends, we expect bankruptcy filings to peak in 2021. During this period of time, as in the financial crisis of 2008 to 2010, policyholders are setting payment priority. Different priorities that they have is they have one where they're going to pay their secured creditors first, then they're going to pay their critical creditors second. And how we classify a critical creditor is a creditor that they need to provide services or products that they can resell to stay in business. And third, what we call selective creditors. Selective creditors, more specifically, are creditors not needed where the policyholder can find additional companies to replace the creditor they're not paying. Kind of like insurance companies fall in this category. They can simply move to a different carrier, get the coverage they need to stay in business, and worry about your debt later. Insurance carriers today, as reported by our clients, are struggling to adapt to the new normal. They're facing staffing and budget restrictions, canceled appearances, canceled in-person depositions, notary issues, and state and carrier-imposed moratoriums. In collecting debt, the state mandates stalled or slowed the collection process. What we saw then was an increase in companies paying their bills slower or asking for settlements. They're asking for extended payment plans, and even some states allowed or recommended extended payment plans. Paying their preferred or secured creditors first became the #1 priority to stay in business. After that, they decided who they wanted to pay and who they didn't want to pay. On top of COVID, you're looking at the impact also now of hurricanes, wildfires, storm damage, civil unrest, all now factor into issues that are going to impact the policyholders of paying that debt. And typically what happens is the debt starts aging out. They become non-responsive, and in many cases the carriers are starting to look for litigation as a means to try to recover that debt. Let's take a look for a minute and summarize some of the consequences. You're getting slower payments, companies are wanting to extend their payments, increased unpaid debt, increased court cases, increase in bankruptcy cases and business closures, increase in personal debt, increased cost of litigation. We're seeing increased default judgments, increases in satisfied judgments, and the increase in post-judgment enforcement and costs. All have been inhibited by the COVID, as well as many of the natural disasters and things that we're seeing in the news. So during the COVID period, not only in the judicial system, but at the carriers, they've had to make adjustments. Affidavits are delayed because typically when it would go to an office for handling, now it goes to your personal residence. Timelines are pushed out now by the court system, at least an additional 60 days for every timeline that you had to meet in the past with regards to filing suit. People trying to be served, businesses are closed, so many companies have to hire special servers to be able to track them down, to be able to serve them the papers for litigation. So there's many delays in serving the documents. Delays in default judgments, simply handling the paperwork and get those default judgments registered because of shortages at court with regards to staffing. Trials are being set 1 to 2 months ahead of filings. To give you an example, in California, they're stated basically that it's a 2-year delay based on the situations that we're experiencing. Status dates are delayed, witnesses and depositions. Some states are starting to allow video. Video is kind of even tough to get when the businesses are closed. Maryland allows Zoom, but you can't do Zoom in Virginia. But some counties in Virginia you can. So we're having to adapt to those situations and keep up with each of the court's adjustments. Scheduled coordination with the courts and counsel is delayed due to backlogs. This does create somewhat of a debtor advantage. Debtor advantage one is balance size, debt size. These business owners understand and know that depending on the debt size, they can simply ignore demands, ignore phone calls, and the debt falling under suit threshold too small to sue will simply be written off. As the credit history becomes worse, you're going to find creditors making decisions not to sue based on the fact that the credit history is poor. To give you an idea, on a 0 to 100, if somebody scores a 25, showing that they have a lot of derogatory information in the credit history, this will work to the debtor advantages of not being a good candidate for suit. Settlement offers pre and post litigation action will increase simply because of the time delays and the difficulty now working through the court. Policyholders will continue to promise filing bankruptcy if they have to pay the debt, or if they do not get a favorable payment plan or settlement offer, or simply policyholders will not respond. Since businesses are closed, phones have been disconnected, addresses are returned mail. They simply move their operations to either a different location or into their home. Policyholders will even threat of a countersuit. They'll demand carriers produce expert witnesses appearing at court, or depositions and court sessions will increase. Sympathetic court jurisdictions will allow latitude to the defendants that they didn't have before, creating more time and cost on the carrier side. More carriers will be demanded to produce expert witnesses during the court session, only to face multiple continuances, not only at the request of the defendant's attorney, but also because court systems are backlogged. Default judgments will increase because of non-appearances, and post-judgment costs will increase as well to try to enforce judgments that are obtained during the court system. So the question is, how to determine in today's litigation climate when to sue or not sue? Today, more than ever, the odds are stacked against the plaintiff. You're having increased court case filings clogging the judicial system. They expect increases in bankrupt cases filed, and businesses closures in 2021 to 2022 will increase. Not to mention that the areas of moratorium at this particular time because of natural disasters and civil disorders causing business closures as well. So the question now is, what do we do today? The object is not just to win a case, because you can win a case through a default judgment, or get a judgment and not collect any money and you didn't win, you actually lost. So what we're going to talk about here is how to triage cases. The object today is to establish a new litigation policy that will not only win a judgment, but will also produce premium recovery and collections. So you're going to need information, and that's called business intelligence. That's going to enable us to make a well-educated decision. First of all, we're going to have the policyholder's payment history and score. 6 months prior to this suit filing, what have been their trends in payment? What is their score? 0 to 100, 100 being the best. If they score a 25, then within their industry, they're in a very poor financial condition. So we need to know that, where they're at, and what their predictive payment patterns are, who they pay and who they don't pay. You have to have knowledge of the cost to invest into the program, into filing suit, to not only file suit, but take it all the way through judgment and judgment enforcement. If that average cost per case is in the neighborhood of $15,000, determined by the cost factors we showed earlier, then you're most likely not going to sue somebody at $20,000. It's too high of a risk. You have to calculate what your risk is and what your return on investment. We're going to help show you how to do that, because those costs are not only hard costs where you write checks for, but it's also soft costs in time, not only in meetings and in travel time, depositions, or whatever they may be. You'll also want to know the specific court jurisdiction and what their administrative policies are, especially now with the changes due to the processes because of the pandemic. What do they charge? What are the costs? Are they sympathetic to the policyholder, or are they going to be sympathetic to you? Technology is going to help in aiding in that decision. Technology that's going to enable you to get credit reports that you can utilize in your decision-making process. The other thing that we need, but we don't have, is a crystal ball. Because, face it, when you go into the courtroom, you never know which way it's going to go. You can believe that you have an ironclad case, and it turns out into the defendant's favor. We can't help you with finding a crystal ball, but one thing we can help you with is the knowledge to help you restructure your best practices. So what we're going to do is make you an offer that if you'd like to have a one-on-one or a group discussion to go into the details on many of the items that I spoke about we're going to be able to give you a listing of all state procedural changes. Simply email us and ask for it. It'll give you an update in the future as well as the changes are being made, because we're tracking that in our litigation department. We'll provide you 2 samples of credit reports, one good, one bad, and we'll show you how you can interpret that data. We have a pre-litigation checklist. The checklist enables you to prepare a score to determine if that score is good enough or bad enough on each individual case to proceed with litigation. We're also going to give you information on where to obtain these credit reports to assist you in making that decision, as well as help you with a formula to understand what your average cost is per case you do file. We'll do all this completely at no cost. All you have to do is send an email to me, or you can reach out to one of the team members. Thanks for stopping by. We look forward to hearing from you.